Hello, everyone. Good morning. This is Lucas Couffier from EU Japan Technology Transfer Help Desk. Welcome to the 17th webinar of the Help Desk. Sorry if my voice today is not as usual, but I'm a little bit sick. I would like, first of all, to really thank my colleague from the Brussels office, Eva, that is helping me out today as usual. And of course, even more, our speaker, Ron Harris, that today is actually connected from the US. He had to stay in the US for work-related reasons, and so he's connected from the East Coast. So it's 4 a.m. Over there, so you can imagine is really very brave. So I will be super short with the introduction today, just telling you that as usual from here, from the first slide, you can find my email. If you have any questions, you can write me about any of the topics related to the Technology Transfer Help Desk. You, of course, have, as usual, the URL of the website dedicated to the Help Desk. And you have the survey that is going to be open until the end of February, specifically aimed at SMEs, so that we can gauge their interest in the services of the help desk and possibly even better them. Eventually, we have, yes, the last URL that you see on the slide is the link to the newsletter of the help desk if you're not registered yet. So just give me 30 seconds to introduce you to the speaker today. Ron Harris is the founder of the Harris Firm, an intellectual property boutique law firm with offices in Washington, D.C. and Tokyo. He provides daily advice in chemical, pharmaceutical, medical device, software, mechanical, electrical, and biochemical technologies. Prior to starting the Harris Firm, Ron gained extensive, in-depth experience in private practice and government service. He was associated with a highly respected patent boutique firm in Washington, D.C. He was also an attorney advisory intern for Judge Terrell, administrative law judge for the Intellectual Property United States International Trade Commission in Washington, D.C., and also a medical device and business methods patent examiner at the USPTO. Without further ado, I would like to introduce and give the floor to Ron. Ron, the floor is yours. Thanks for being with us today, for the great effort, and welcome.
Thank you, Luca. I'm sorry to hear that you're sick today. I'm a little drowsy, but it's really a pleasure to participate in this event, and I hope that we're not too narrow in focus, but really our expertise and my perspective is that copyright and trademark and trade secrets aside, because most IoT inventions can be reverse engineered, the most robust type of protection is patent protection. And so with all respect to, of course, the most efficient patent system in the world, in my opinion, that being in Germany, which of course in Japan there are also great advantages. I think it might be useful for a largely European audience to consider what I believe to be the best bang for your buck, so to speak, in terms of patent protection, and that I think it's still the U.S. System, mainly because the damages available are so great, as well as the immense amount of evidence gathering that can be obtained for filing in other jurisdictions where there is no discovery and where it would be very difficult to obtain that evidence otherwise. So that's my perspective. I'd love to hear comments from everybody who is participating on your perspective. I understand we have a diverse group. Some are diplomats, some are perhaps at universities, some are business owners. I'm typically speaking to patent lawyers, so if it gets too much into the weeds, please forgive me. And without further ado, let me begin. So the title of this talk is U.S. patent protection of technologies that are related to the Internet of Things. So let me begin with the first slide. Just as a brief outline, you can expect that we'll go over these 7 topics. I'll briefly talk about what is the Internet of Things, what are certain trends in the Internet of Things regarding patents. I'll talk about the largest hurdle to receiving valid, enforceable, meaningful patent protection for these types of inventions, and that is eligibility issues, because the Internet of Things is basically a software play, and although software per se is not patentable, I think most of us are well aware that there are ways to either obfuscate or, better put, look at the software inventions involved from a different angle in terms of the devices and methods that are claimed. And the Alice case, which was decided by the Supreme Court a few years ago, is the fundamental leading case in terms of eligibility. Keep in mind that Alice does not simply adopt EPO law or European law. There is a very different kind of analysis. We'll look at some successful post-Alice cases where inventors and patentees were able to enforce their patents, even though there were questions about eligibility in the IoT realm. And larger than that one main issue, there's also issues regarding just how to figure out how to satisfy the 4 main requirements of a valid patent. Those being, of course, eligibility, novelty is number 2, inventive step, or what we in the U.S. call non-obviousness, and description, or the description that you provide in the claims must be clear and unambiguous, and it has to be, the claims have to be supported properly. So I'll go through one set of claims that specifically goes into some problems in a claim and some amendments that would optimize your chances of having the claim be found eligible, and also being found sufficiently definite in terms of the description being unambiguous. And finally, I'll have some summary comments. So let's see, moving on. The Internet of Things, as we all know, is a network of physical devices, vehicles, home appliances, and other items embedded with electronics, software, sensors, and connectivity that enable these objects to connect and exchange data. Each device is uniquely identifiable through its embedded computing system, but is able to interoperate within the existing Internet infrastructure. It's important because it will change the way we live, and it will certainly generate new revenues and industries. It's estimated that the global market value of IoT devices and platforms will reach $7 trillion US dollars globally by 2020. A few trends we can see over time. If you look at the, we have a Cartesian XY graph here. As we see IoT and its reach into our lives and its manifestation, over time we can see that back in the early 2000s we had RFID tags in the logistics realm to help with supply chain. Then we have surveillance, security, healthcare, transport, and food safety management, document management for cost reduction in various vertical market applications. We see just generally over time locating people and everyday objects as devices are fine-tuned indoors to receive. I think we meant to say geological, but there's other types of signals, and so forth and so on. So we see other technologies, teleoperation and telepresence, ability to monitor and control distant objects, and that's brought about by increased miniaturization, power efficient electronics, and the available spectrum. And that's in the physical world web. So we see each of these applications and developments in the Internet of Things over time. More trends. For example, we see the European Patent Office seeing a trend toward patents for sensors to collect information, which is then transmitted over networks to be aggregated into big data. And data will seem to be the main economic asset in this new environment. But for it to work, there's several building blocks: greater connectivity, cloud computing, artificial intelligence, in many instances 3D printing, smart factories, grids, and homes. And these building blocks have a few things in common, but one again is that they're software driven. Just as an overview of some of the leading patent filers in the IoT field, we can see the writing is fairly small to the right of the screen, but we can see that, for example, Samsung and Qualcomm have filed many patents in this area and received many patents. Their sectors include electronics, telecom, of course, software. Those are sort of artificial boundaries at this point. Qualcomm is a leading filer in multiple jurisdictions as well as in PCT filings. The network layer has the highest number of patent filings and accounts for about 62% of all IoT patents. And that's a little bit of a deeper layer, and I think part of the reason is because it's more likely to be eligible, and I'll get into that when we talk about Alice. Because when we have an invention, we really cannot simply take what was done without a computer in the past and apply it to a general purpose computer in such a straightforward way and expect to receive a patent. We have to dig deeper into the stack, or we have to really think about the efficiencies created in making actual computer machinery operate more efficiently, or we have to think about what about the invention, for example, increases data security, what about an invention increases the efficiency of the electronics involved, and not simply whether our orange juice is delivered to our door more efficiently. That's not exactly what the patent offices are looking for. If you have a in that example, if you have some kind of data gathered about your breakfast drinking habits, and when your refrigerator determines that you're out of orange juice and orders it, well, we really have to dig deeper and think about what about that invention, or what thing about that the narrow implementation of that concept is eligible. So we just getting back to the top filers trends. Samsung is a key patent holder in most layers of the IoT technology stack, and its patents address multiple application areas. We see IoT patent transactions per year have continued to increase since 2011, little by little, and more and more in the last couple of years. So patent filings related to the upper layers of the stack were very few up until recently, but they've increased, I would say, about 6 years ago. Getting to the most critical aspect of patenting IoT inventions, in June 2014, the U.S. Supreme Court decided the Alice Corp v. CLS Bank case, and that has affected many U.S. patents related to computer and internet-based technologies. That case laid down a new test for determining what types of inventions are patent eligible. In particular, you might have heard of the Bilski case. That was really modified, and the Alice test grabs most of its foundational concepts from actually a life science case called Mayo, which was about a medical device, not a medical device, but really a medical analysis patent that would measure some kind of natural relationship, basically some substance would be absorbed in a human body, or would be in a human body and would be metabolized at a certain rate, and the discovery of that rate was implemented quite broadly. And so Justice Breyer complained, and when he wrote the decision, that it seemed to be unfair. I think it was sort of I think he had a fairness qualm, and unfortunately, I think, as often happens with Supreme Court decisions, that it introduced a lot of confusion and a lot of new concepts that we're still trying to figure out. But the Alice case sort of ran with that in the realm of computer and software-based inventions. And that test can be summarized as follows. Even though the U.S. patent statute allows for any a new process or new machine or manufacture or composition of matter, there are three fundamental exceptions that are long-standing in Supreme Court case law. Unfortunately, no matter what Congress does, it seems, and that's another issue, but I won't get too deep into constitutional law. In any case, an abstract idea, a natural phenomenon, or a law of nature are three exceptions to that general kind of those statutory areas. And so an algorithm, a mathematical formula, even if thrown into a process without significantly more than just that idea that transforms it into a patent eligible invention, then that claim and that subject matter cannot be patented. And ever since that case, patent applicants have been working hard to interpret the meaning of abstract. What's abstract to one person isn't necessarily abstract to another. Likewise, significantly more is fairly subjective at first glance. So in the meantime, courts and agencies around the country have used the Alice test to strike down a number of software-related patents. There are, however, at least two successful post-Alice cases that the Patent Appeals Court, the Court of Appeals for the Federal Circuit, have decided. And really the first and most encouraging one was called the DDR Holdings LLC v. Hotels.com case, where various objects from one website was integrated into another, and that had to do with some, I believe, some internet advertising. And so these two court decisions, let me go back, provide examples of something that are significantly more than the abstract idea itself. So in this DDR Holdings case, there was a patent that gave an internet-based solution to solve a problem unique to the internet. So it had to do with marketing on the internet. It wasn't just marketing per se, and the problem was necessarily a web-based problem. Another reason the court found it to be patent eligible was the whole idea of using sort of one advertisement and taking an object from one web page and integrating it into another company's sort of aggregate web page of several advertisements. Didn't foreclose other ways of solving the same problem. Basically, I believe the invention had allowed Hotels.com to use its own branding but take cached objects from other sites and integrate them so as to be able to more effectively advertise across different websites. And that was really something unique to the web in terms of the problem that was solved. It wasn't simply putting something that would have maybe formerly been in a newspaper on a computer. There was a particular technical problem there that was solved. And the claims were sufficiently narrow so that the solution was not the only one. It did not preempt the entire concept. And it also recited a series of steps that resulted in a departure from the routine and conventional sequence of events outside of a computer environment. A second case that was positive and showed where you can overcome the Alice ineligibility problem is Fairfield Industries versus Wireless Seismic Incorporated. These claims outlined a specific method of data transmission that were a new, useful, and practical application of a generic relay system. So it was a new, practical application beyond the generic system's functionality. There really was something more than applying something to a computer or routine elements that were then put in the context of a general purpose computer. Those claims recited a close connection to a specific machine in a seismic acquisition unit. And one thing to keep in mind when you're drafting or if you're disclosing your inventions to your patent attorneys and you do want to file eventually in the U.S., maybe you want to receive financing, that's always good. A lot of Silicon Valley and Boston and other venture capitalists are very interested in whether you can protect your patents in the United States. You'll want to describe the claim language in a way that doesn't necessarily preempt everything, and that shows sort of a narrow solution to that broad problem. That is certainly one way to approach overcoming eligibility issues. You can also, obviously, just as an aside, look at USPTO guidance on subject matter eligibility. We'll provide other very helpful examples of claim elements that were significantly more than an abstract idea. And we also have seminar materials, I believe, on the, if I'm not wrong, Luca, on the EU Japan Center's website when we had a seminar at the Tokyo American Club in Japan, and we went very much in depth with a lot of examples and guidance. In addition to eligibility, we really have to think about, or in addition to some of those cases that talk about making claims to something that are not simply abstract, or making claims to something that are abstract but do something that is more than abstract, and those are really the two ways around the test. There's other issues, and of course those include inventive step, and they also include description issues. So I'll be talking about sort of a typical, let me just sort of talk about a typical kind of setup on an IoT invention. If you look at this on the left side, there's something that was developed by some business analysts at Deloitte that basically put in a circle there sort of a chain of development or a chain of functionality. You can see there's basically there's 5 stages, and it's fairly involved, but usually we have obtaining data, which is not eligible. Excuse me, that should be an I instead of an A there for eligible. Analyzing data, which case law is also saying that merely analyzing something that could be analyzed even slowly and methodically by a person is not eligible. And then there's usually an integration and an application of the analyzed data at a device level. It's important that whatever is invented, that you make sure the claims do not just talk about gathering data, because that is not eligible for protection. Likewise, analyzing data is just analyzing the data. Even if it's a machine, if the steps functionally just analyze and or obtain data, you're not going to probably satisfy the eligibility requirement. There needs to be an integration and claiming that integration, and then for practical reasons it should be at the device level. If the steps performed could be performed in a country that doesn't have satisfactory patent protection, let's just say China, or we could say Guatemala, we could say any place in the world, really, outside of a few fairly reliable patent systems. If the analysis is done in the cloud, then we have to think about making sure that our claims are claiming steps that are performed in a particular jurisdiction. And as I mentioned before, the claim language should be covering something that's eligible, a result that makes a machine more efficient or is intrinsic to computer science, and not simply, putting, some hedging business method on a computer, or in the IoT realm, determining when your orange juice is low in your refrigerator and then ordering it. That type of claim simply isn't going to be accepted. You have to think about what in your particular implementation makes the network that transfers that data run more efficiently. Or is there some particular portion of your idea, your invention, you have to tease out something that is really intrinsic to some AI kind of analysis, and bring those things together. That's also true for inventive step analysis. So instead of listing elements in a very methodical and sort of robotic fashion, it's very important to think very deeply and think very carefully about what is economically viable, of course, but also what can be protected. And so when our clients come to us, I'm often, especially a new client who's not familiar with patenting, I like to say that their invention is usually like a sphere with maybe 100 facets, 100 sides. And we try to identify the sides that satisfy all of the patent requirements and their economic requirements. What is it that their competitors are going to want to copy? And so we find the facet of the invention, or the facets that satisfy all of those. Satisfies what is eligible, what is inventive, what is new, and what we can describe clearly. So basically, in addition to eligibility, we need to make sure that the claims, as much as possible, are fulfilled. Each part of a claim is done by one party, okay, and meaning that, or one device, really. So it's the device that performs the steps. So it's a little misleading to say one party. One device is performing all the steps. And that's simply because we don't want divided infringement. We don't want one component in Canada and another component in Israel, and then have a third component maybe in the United States, and each one performs a step in your claim, but no single device performs all three steps. Well, if you don't have that, then there's a chance that you'd have divided infringement. Now, recently, the U.S. courts have loosened up that standard, so it's not as tight, but when you file in other jurisdictions, that standard, the vicarious liability of joint actors is not so easy to prove. If the actors are just partners, or if maybe there's no economic tie between them for some reason, or no one controls the other, then this various theories of vicarious joint liability don't apply. So always be safe than sorry. There are people in the U.S., legal scholars, who believe that the recent softening could be overturned ultimately because of Supreme Court case law, the Arrow 1 case from 1962, for example. A lot of people, including myself, believe that Judge Rader of the Federal Circuit got it wrong when he softened the requirement for divided infringement, meaning that you need every step in a claim performed by the same device in the same country. There's also a BlackBerry case that has to do with that, and I can get into that later. And finally, you'll want to have something that is directly infringing and in the jurisdiction at issue. You don't want to have to show direct infringement of your customer, and then on a device that they're using, maybe it's their phone, maybe it's their refrigerator. You want all the steps to be performed there. So if there's analysis that's going on in Korea because you're competing with LG, and the data are sent to Korea, or they're sent to Mexico or wherever, you don't want to try to prove infringement because you can't really very easily discover it. A lot of times it's more difficult to get discovery outside of the U.S. And it's even if you do get it, it's just not necessarily as reliable. There are a lot of complications that come up in that kind of discovery, and certainly a lot of cost. Just to kind of move on to our next slide, here's an example of an IoT claim. In this first slide, I talk about sort of amend it, really focusing on how to make this claim more likely to be held eligible. And by doing so, we accomplished that by amending the preamble. Okay, the preamble is an apparatus for providing an application for processing big data comprising. Well, it's very important to incorporate hardware in an apparatus, specific hardware. And it's very important to talk about how this invention makes the machine run more effectively. And so when you're drafting your patent, you really want to focus on that aspect of the invention. So, for example, we might change that preamble to a processor-based terminal. Remember, we want the terminal, like the refrigerator or whatever the consumer item is, okay? And that terminal is for example, you would say selectively reducing data available to or processed by one or more computers communicatively connected to a digitally stored and operated database. So, for example, maybe some aspect of your IoT invention reduces data flow. And if so, that's very good. Or maybe some aspect of your IoT invention just improves data security by running more data through some kind of encryption algorithm. Or maybe some aspect of your IoT invention increases the operational efficiency of the computers in a network. And then, of course, the first part of the body of the invention after this preamble would be at least one processor and at least one memory storing instructions that, when executed by the at least one processor, cause that processor to, and then you get into really the function of it, the so-called algorithm that the software is performing. And in U.S. law, that functionality is presumed to be structure. It is under black letter case law structure, so you don't have to worry about that. But this language is quite effective here in terms of this at least one processor, because that makes sure that someone doesn't try to design around. If you say a processor, they're going to quibble and they'll have it done on two processors, and then you'll have an argument. You want to eliminate those arguments, those kinds of silly arguments that waste your time and money. So that talks a little bit about eligibility. Let's go to the next slide and go a little bit deeper. we're at 4:42 my time, so it's wherever you are. I imagine it's about 6:42. You're probably ready to go eat dinner now. But this claim also really fails to satisfy the description requirements for various reasons. If you use terms like setting unit or access unit or all these units, it's like you're sort of playing with something called means plus function language. It appears that you're sort of moving in that direction, but you don't want to seem like it, so you're using this word unit, which is deemed a nonce or placeholder word. And because of recent case law in the U.S., that is ambiguous and very possibly could be deemed as indefinite. So we removed some of that language. We removed some of the possibility of not infringing directly, okay, by one party in one jurisdiction or one device in one jurisdiction. And frankly, without getting too much deeper, the old claim really provides scarce damages because so much of what could be happening in that claim is happening far away, maybe outside of your jurisdiction, and it's very hard to quantify. So that hopefully gives you some idea of some of the pitfalls in drafting and obtaining patents that would help you, if you're on the innovation side of things, to provide the best possible disclosures to your counsel. So as a summary, you can get IoT patents after Alice. Innovators need to focus patents on narrow ideas that don't preempt an entire idea. Too broad a statement of the idea in the claims would exempt the entire idea and cause an invalid patent or unpatentable invention. You can specify the use of a particular hardware. If an inventor limits the patent to a particular set of devices in a particular environment, it's possible that an invention, even a software-related invention, will be found eligible. Mere data collection isn't eligible, so don't claim just data collection. Claim an integrated result that makes the machine perform better, or what can be done by pen and paper and a person is also typically ineligible. Just taking that and putting it on a machine is not enough. So don't just claim analysis, which, by the way, can be in a computer anywhere in the world. Claim what is inextricably tied to the computing going on and the data flow and integrating several devices and the result at the consumer device endpoint. Finally, can you or similar, can you get a patent post-Alice? Yes. Hold on just a second here. Same ideas, but just one idea. Again, you have to focus on narrow areas of protection, and it can't be too broad. Hold on just a second. Let me go back here. Another approach is to provide specific operations, such as detailed algorithms. Broadly, trying to patent straightforward steps in an algorithm would run the risk of invalidating an issued patent. So you might break various steps into separate applications. Patenting narrow inventions by specifying, for example, a novel and inventive step of your invention would produce patents with a better chance of surviving the Alice test. And finally, in terms of broader eligibility and other aspects, you can get eligible valid IoT claims. Innovators need to focus on claims, again, that have integrated results that are inextricably linked to computer science, or smaller pieces of an idea that are not as narrowly focused and do not and exempt an entire abstract concept. Claims should focus on steps that are all necessarily performed in one jurisdiction. Claims should focus on steps that are performed on one consumer device to remove device infringement. Three approaches are to focus claims on an aspect of an idea that are not mere data gathering, not taking an old method and putting it on a general purpose computer in the claims, or simple analysis that someone could do on their own, but it's just put on a computer. Write claims with what happens on a consumer and terminal in mind. And finally, identify what facet of your invention or product satisfies more than just what is immediately apparent commercially or technically or to a layperson. Consider those things because that's all valuable, because the layperson or a jury or judge have a great role to play, and you should write for them. But in addition to that technical and plain language and the commercial, what would be infringed aspects, you also have to consider eligibility and really consider how the machine is being improved, and not just say that now we can, order our orange juice automatically. That's you have to think more deeply. So I hope that's helpful to you. There's a lot of subject matter in there. I really didn't even get into Inventive Step, but thanks for your time, and if you have any questions, please let me know.
Thanks very much, Ron, for your presentation. Really appreciate you doing it at almost 5 a.m. now, U.S. time. If you agree, we can now move to the Q&A session, I guess. And
great.
Yeah, perfect. And if participants have any further questions after Ron's presentation, please feel free to type them in the chat box. We'll give at least a couple of minutes. Thank you.
In the meantime, Ron, this is Luca. I would also like to thank you on behalf of everyone, I would say, because your presentation has been super clear. I would say hyper clear for being almost 5 a.m. And I have maybe one question that I have, so that I also can give some time to the audience to think of other questions for you. How would you, and this is very general, I know that you practice US law, but anyway, you are, as most of the most successful patent professionals, you know what's going on around the planet, and especially in the jurisdictions that are more important. So what would you recommend to a small, medium enterprise that is coming to you and is interested in filing an application in this technology area? What would you recommend to go for a PCT? You would probably explain what are the pros and cons of different jurisdictions. What would be the best approach?
I think that the best approach is first of all not to simply file a provisional application half-heartedly. I would say you really don't need to file a PCT from the start. If you've already have your funding and you know that you will be filing in more than just a handful of jurisdictions, then maybe a PCT from the beginning would be fine. But it really just depends on it really just depends on their situation. If their most intense competitor is in France, for example, then I would suggest possibly filing their first application in French language in France. And then what that'll allow them is to have a search report by the EPO examiner that will ultimately take their case, and the prior art that examiner will probably use to reject claims within 9 months. And as you know, Luca, that means that the applicant can update their specification to include facets of that 100-sided sphere that I mentioned that maybe they didn't realize were there. Maybe their attorney and maybe they did not anticipate certain prior art. And the ability to amend in Europe is really more difficult than anywhere else. So you can't rely on the drawings for amendments, and you can't play with the language very much. There needs to be almost a word-for-word recitation of any kind of amendment language. So in that situation, I'd say you might consider drafting it in English if French is not your cup of tea, and then translate it into French or Italian. I think Italy has a similar kind of advantage, although we typically ask a French firm to file in those cases. If you're looking for, on the other hand, if you're looking for investment from like a private equity firm in the U.S. or an angel or something in the U.S., then I would suggest filing first a provisional application in the United States, and then perhaps a Track 1 application that could be granted within a year. It's hard to answer your question because each client and each situation is different. I hope that helps, but there are time considerations, there are support considerations, there are who's paying the piper, who their investors are, those kinds of considerations. Does that help?
It does help. It does help me, and hopefully also the audience. And in the meantime, I saw that in the chat window there is a question. I don't know if you can see that.
Okay. Oh yeah.
Yeah, I can read it out loud as
okay.
well. We have a question from George, and to quote, you mentioned that being less broad would be good to get around eligibility issues, but doesn't this ease circumvention by others?
Yes, it does. So there's a balance. Okay, George. Yeah. So it does. It's sort of like this. It's like if you saw A Beautiful Mind. If you all go for the blonde, everybody loses. If you know what I'm saying. Sometimes you've got to sort of know your limitations, and so there is a balance, and finding counsel that can really help you find that balance is your best thought. A lot of times people have a particular embodiment, and they will attempt to sort of claim everything and fill it in with all sort of prophetic examples. And that's very helpful, certainly in the chemical arts, or certainly in the realm of inventions where you don't have these eligibility issues. But it really narrowing the focus of your claims is not the only solution to the problem, but it is one arrow in your quiver. So I hope that helps answer your question. So, okay, great.
Thank you, Ron. I think it helps. And I guess we can give a few more minutes for any further inquiries, and then we'll close the chat.
Okay.
Yeah.
So maybe I can take another second. For another question, you mentioned at the beginning, rightly, the importance of the connection between these kind of technologies and the use of data, processing of data. What would you recommend? So we all know that we're also approaching very important date for a lot of companies around the planet, not just for those that are in Europe, but for those that are dealing with someone in Europe. So it's the adoption of the new regulation in Europe concerning privacy. And so many of these technologies will also involve necessarily the processing of data, or personal data in some cases. What would be once again the best advice to to give? I know that these are two different branches of law. One is privacy, one is patent law. But anyway, in very general terms, what would you recommend to someone that is coming to you with the technology that you know will involve the processing of personal data, for example?
Seek the advice of local counsel. I mean, that's what I would do. I am not an expert on EU privacy law. So it will be useful if I suppose the solution that I propose in these claims would be not so bad because when you focus on what happens at the consumer device level, then where the data comes from or goes to isn't really so relevant. So I guess there's a nice sort of congruence. There's a good coalescence of privacy law concerns and patent enforceability. So it sounds to me like, I mean, my understanding is that the EU, is it a EU regulation or is it a directive?
It's a regulation.
Okay, so my understanding is that a big concern is that data would leave the EU or come in from the EU. Is that, or are there certain types of data that have to be stored within the EU? Is that right?
Oh yeah, you mean for the applicability of the of the provisions, or in general? I mean, the example was just related to, as an example, to the EU regulation, but it might be related to the different privacy laws around the planet. The idea was just
Sure.
just
So
understanding how complex things are becoming, because now you think that you have a new device, maybe you're providing a service like, I don't know, then a platform as a service that is connected to these devices that have sensors and they're collecting data. And then you have all this also interconnection about patent law and privacy.
Sure. I think that I mean, typically when I think about unintended consequences of claim drafting, one thing I can answer is that a lot of times if you find somebody who has similar prior art, like a similar invention, it's very useful to look at your patentability search and not only try to claim around what's already been done, but also use that search to provide a clearance opinion. So you'll find very similar technologies by your competitor. And when you're drafting claims, you're going to want to draft the claims so that you can get protection that doesn't necessarily require that you practice their claims. And so what I mean by that is taking this approach doesn't make much difference in terms of whether you get a patent or not, but from a licensing standpoint and from a litigation standpoint and just a strategy standpoint, if somebody patents, one of your competitors patents A, B, C, and D, and you have, and your device sort of, you're considering A, B, C, D, E, well, your device, not the claim, but your device practices their invention. But if you could claim it instead of A, B, C, D, E, maybe you could claim it A, B, C, E. And if you get that claim, it's very good because you're not, first of all, you're not in order to practice your own patent, you wouldn't be admitting that you're infringing theirs. And so when it comes to enforcing at the International Trade Commission, when it comes to getting lost profit damages as opposed to just a reasonable royalty, and lost profits are usually much more valuable, you have to show that you would have sold that infringing product but for the other person's infringement. So when you're talking about getting money from somebody, the lower threshold is reasonable royalty, okay? And it looks at the hypothetical bargain of how much licensing fee you as a patent holder could get the day before infringement began. And that's usually like a percentage, you know, whatever, 1 to 15% depending on the technology. It could be higher. But that is not nearly as much money as you can get is if you say, I want to get all their profits due to the infringement. And in that case, you have to prove that, oh, I had my own product on the market that was covered by my claims. So you see what I'm saying? So you say, okay, so I have a product ready to make that case and get lots of profits, A, B, C, and E. And so your patent covers your product. But when you file that lawsuit asserting that, unlike the situation where you had A, B, C, D, and E, you're not admitting that you infringe your chief competitor's patent. So you don't want to have your hands behind your back when you're trying to enforce against maybe somebody else. Does that, I mean, I hope that was clear. So, but, you know, regarding privacy concerns, I think I would just, you know, keep it to one jurisdiction, and I think that kind of helps. I think having it on one device kind of helps because you're not suggesting that things would go out of a country. You're just saying that everything that we're claiming happens on the consumer device that we're selling. I mean, primarily, you can go ahead. I think there's nothing wrong with, you know, in software-related inventions, you want to generally want to claim the method. You generally want to claim a system. You generally want to claim a terminal that performs all the steps. And you generally want to claim maybe a computer-readable medium. So does that help answer?
It does. Yes, absolutely. In the meantime, I can see that there are no further questions. So I would love to thank you once again for the effort. It's been great to have you with us, and also, of course, Eva in Brussels that helped us out, and all the participants that were with us today. We should have the next webinar at the end of March, number 18. So hopefully, I'll see you online. Thank you again for being with us.